Hey guys, Amateur Law Prof here, and I've got an update for you in the Lively v. Baldwin lawsuit. Now, in case you've been living under a rock, Lively's suing Baldwin for $250 million, claiming he ran a coordinated smear campaign, and this time it involves a subpoena to Perez Hilton by Lively's camp. Now, the problem here is that they sought unpublished material, personal messages, and contact from other creators. Perez Hilton is seeking to quash, that's a fancy lawyer word for stomp out, the subpoena, claiming that it impinges his journalistic freedom. So can you even do that subpoena? Here's where we get into the actual law. Since this case is in federal court in the Ninth Circuit, the Schoen test applies from Schoen v. Schoen. This is based on a 1972 Supreme Court precedent. Basically, there's no blanket privilege. You have to engage in a balancing test. So to force a disclosure, you have to show three things. First, the info is highly relevant. Two, you can't get it from anywhere else. And three, there's a compelling interest that outweighs the press freedom. It's not an easy test. Gonzalez v. NBC, they sought unaired footage from Dateline. The court said no. Schoen v. Schoen involved the notes of the person writing a book. The court said no. It doesn't matter if you're Bob Woodward or a blogger with a glitter font. The First Amendment doesn't care about what font you use, it still applies, and journalistic privilege is still there. Now, Perez Hilton did switch sides halfway through. He started out Team Blake, and then Baldwin dropped some receipts, and Perez, flipped on her. But flip-flopping on the internet isn't a crime. If it were, half of Twitter would be in federal prison. So, no, Blake's team doesn't get a fish through the inboxes just because Perez said he didn't like her deposition lighting. This is about journalistic integrity. This is about power. And the First Amendment has something to say about that. Now, turns out, he was mean to me online isn't really a valid subpoena standard. Who knew?